Good morning, guys. Good morning. Good morning. Good morning. Um, I'm waiting for my reader to come. Shout out to Miss Liz for helping the sister out. So I'm waiting for her to come. She has the paperwork. I sent it to her already. As also I have my backup, Miss Randa Baby. So just in case Liz gets conked out, Randa Baby is step in. But let me say hello to you guys in the chat. Hello, everybody. I am so glad that you guys are here with me this morning. Welcome to Infamous Sylvia. Those who are new to this channel, shout out to you guys for taking the time out to be with us this morning. This morning, my dear people, I was on my second channel. Those who don't know, I have a second channel, and we were just sharing some reaction to a video. And then one of my wonderful folks came into the chat and they said, "Hey, Doug Daly just dropped a video. A motion that's still submitting. This is a good, juicy one." They said it's real juicy. So I said, okay, let me get on my main channel and get the juicy paperwork. So I got the juicy paperwork. It's 233 pages of it. And the paperwork has to do with a supplement to get this judge off. Uh-oh. I think both Judge Glanville. And here go my girl right here. There she is. Hey, Liz.
Hello, good morning.
Good morning, my darling. Thank you so much for being willingly able to help your sister out who can't read.
That is some funny stuff. Can't read it
I
all.
can't read at all. Okay.
I don't know how you made it this far, though, huh?
I don't know. I can't read at all. Somebody please put a membership link for Brooklyn T. She wants to be a member on this side as well. But anyway, guys, let me go ahead on and finish saying what I was saying. Steele has submitted a motion in regarding to the I'm low. You are low, Gemini. You might have to get a little louder. Come closer to your phone or something.
Can y'all hear me now?
Much better. Yay.
Okay.
All right, guys. What's gonna happen is Liz is gonna read, because Liz, you don't have to read the whole 233 pages, y'all. It's 233 pages, but the most of the meat and potato is on from 1 to 27 pages. So we're going to go ahead on. We're gonna read in a few minutes, but I'm gonna wait a few more seconds to get folks in the chat, because once she gets started, they're gonna have to go hit the replay or something else, because it's a lot to read. So, I'm not even reading and I'm tired already.
Get in here, guys. Get in here.
Get on in here. Like Armand used to say, get in here, get in here, get in here. So, all right, y'all ready to get it going now? Randa, look at you digging me, messing with you. You digging me, you better come up here and help out, All right, okay. Yeah, I will not be able to see the chat. If you guys are doing any kind of super chats or anything like that, I will give you guys the shout out after the reading. So please, if you're sending any kind of financial blessings, just go ahead and send it when you want to, but I will give you guys a shout out after the reading is done, okay? So don't think I'm ignoring you. I just want to get this finished, okay? So I'm going to be sharing the screen with you guys of this motion, and while Liz is reading. So I think I talked enough for some of you guys to get in here. I just want to get it started because I do not want to be on this live all day long. Okay, so we will get started now.
Where's Randa, my reading partner? She's
Randa. She wants you up here, Randa.
27 pages. We gotta share this, I think.
Yeah, y'all need to buddy together. Hold on a second. We're gonna make sure, Randy. Hold on. Hold on a second.
I'm just playing. If she's not ready, it's cool. I was just playing, but if
you know what I want you to read? I want you to read those last page. When Kenneth Copeland Jonathan Melnick, I want you to read that email. And I also want you to read, yeah, you know, the ones all the way at the end, right before it close out. Page, what page is that? The bottom, you know, page 232 and 231. Those
the
are
last few pages of the
where it says Exhibit 1. That's going to be at the end. You're going to read that, but I want you to read the meat and potatoes in the beginning, so they can see that. Okay. All right. Let me go ahead and let me see if Randa's here so she can get on in here.
I can start if you want. Randall, if she's not ready, she could do the end, but.
Okay. I'm going to put it up now for everyone to see. Randa, get on in here. Thank you, Brooklyn. Shout out to Brooklyn for new membership. Shout out to Brooklyn. All right, let me go ahead on and do this. Guys, here we go. Can everybody see that? Let me get me and her out the way so you guys can see it all the way. I'm going to try to keep up with her, keep this pages going. So I won't be able to see the chat. So don't get upset with me to, you know. Hey, Randa, did you take care of the thing that we're supposed to take care of? You know, the thing that you need to do for me? I don't want people to know our business, but they said footnote 3 is good. Patty must have been reading it. Okay.
I'm going to read yeah, I read it too. The 1, 2, 3, that's up the top right here. I'm going to read the footnotes.
Okay. What's my name? Your name is, okay. She did it. Okay. Rand, hit the link, please. Hit the link. Stop talking about what's your name. Hit the link so I can put you up. Put my seal. Keys, I was told with those type of document, I'm not supposed to put my what do you call it? What's the name on it? Because there's
the watermark.
My watermark, yeah. Now, if it was a transcript, I could do it because, you know, transcript, you could purchase it and you could put your name on it. But the motions like this, they said
public.
Yeah. Now, transcript, you can do it. Thank you, AR. All right, y'all ready? Y'all ready to get going? They can hear you loud and clear. Randa can do a test run for your voice. I know they can hear you.
Of course, they can hear me.
You can hear me, Randa?
Yeah, you sound a little low.
Come on in louder.
Loud enough? All right, let's go. Let's go. Supplement to motion to recuse Judge Glanville. Comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby timely files a supplement to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. Number 1, this supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, Exhibit A, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall not be later than 5 days after the affiant first learned of the grounds for disqualifications. But I'm going to go back and read the footnotes. Sorry. Number 1, footnote. This motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. See Reed v. State. Number 2, this motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's reelection campaign. Also, in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's reelection campaign. That's crazy. Mr. Williams' trial has been ongoing since January 4th, 2023, and therefore includes April of 2024. See Mondi et al. Versus Magnolia Advanced Materials, Hilby Hill, Georgia Transmission Corp. v. Dixon. Number 3.
Dang.
That's right.
I'm sorry, y'all.
Crazy. That's crazy. Number 3, undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done, though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. Shots fired. Okay, see Exhibit A attached here to joint affidavit. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25.1 if it is filed within 5 days after the affiant first learned of the alleged grounds for disqualification, with it excluding Saturdays and Sundays. See Mayor and Alderman of the City of Savannah v. Batson Cook Company. Thus, this supplement to motion to recuse is timely filed as the additional reasons for this recusal were first learned on Monday, July 1st, 2024, when Judge Glanville permitted the court reporter to release to undersigned counsel the transcript of the Monday, June 10th, 2024 ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorney Bumpus, and her client, sworn witness Mr. Kenneth Copeland, and others. See Exhibit A, joint affidavit attached here too. See Exhibit B attached here too. Transcript of the June 10th, 2024 ex parte. This timely filed supplement to motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville on Monday, July 8th, 2024. See Mondi et al. Versus Magnolia Advanced Materials. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel lawyers Love and Hilton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. Exhibit B. Judge Glanville, lawyer Love, and lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply as Judge Glanville has not acted as judge, but morphed into an essential part of the prosecution.
I'm sorry. I somebody called me. I lost my spot.
That's
you
okay.
tell me where you at?
I'm right at the last line. See, for instance, Johnson v. State, the judge's conduct, including ex parte, next page, communication with the prosecutor during trial, resulted in the appearance of bias, requiring reversal of the convictions and sentences. USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep the secret by referring to the meeting as privileged and describing the improper secrecy as sacrosanct. See Exhibit C. Judge Glanville has totally abandoned his role as a judge and has become a prosecutor against Mr. Williams. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Number 6, Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of same. See Exhibit C, D. Footnote 4. Sacrosanct means most sacred or holy, inviolable, immune for criticism, just the definition. Number 7, Canon 2, Rule 2.9 of the Georgia Code of Judicial Conduct forbids a judge from considering ex parte communications as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communications at this ex parte hearing were privileged. See entire record of the case, the entirety of Exhibit B and C. Attached here too, see also Exhibit E, attached here too, order of contempt and incarceration for Brian Steele, filed on June 10th. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties or their lawyers concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts, or court personnel and settlement conferences. Code of Judicial Conduct, Rule 2.9a. It is also clear that ex parte communications are presumed to have been in error, and once a party has shown that a judge has received an ex parte communication, there is a presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. See Hargis v. State. In the case at bar, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. Compare in regards to Martin. Ex parte letters sent to judge by witness was not harmful error where the party asserting the error did not argue that the judge responded in any manner or gave the letter any consideration. As shown in the joint affidavit attached hereto as Exhibit A, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate for the Fulton County DA's office as he dispensed legal advice and supported lawyers Hilton's and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. See Exhibit A, joint affidavit, see Exhibit B, entire transcript. In light of this ex parte proceeding, it is impossible to conclude that Judge Glanville is impartial and not a member of the prosecution team. Number 8, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the Proceedings Code of Judicial Conduct Rule 2.11. Judge Glanville has been derelict in his judicial duties and must be recused. See Code of Judicial Conduct Rule 2.11. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10, 2024 in open court, lawyers Hilton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams' case. Number 9, the reference sections of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it is the judge's duty to disqualify himself as soon as he is aware that the grounds exist. See Pope v. State, which provides that no justice, judge, or magistrate shall accept from the parties to the proceeding a waiver of any ground for disqualification, including cases in which the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. This includes ex parte communications. See also Mayor Alderman, City of Savannah v. Batson Cook Company. An appellate court reviews a trial court's ruling on a motion to recuse under former Canon 3E, now Rule 2.11, de novo rather than for abuse of discretion. Number 10, in the case at hand, the state cannot show that Judge Glanville's lawyers Love's and or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his 2 cohorts from the Fulton County DA's office on Mr. Copeland changed Mr. Copeland's stance not to testify against Mr. Williams. If Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation. Intimidation tactics thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer Love, and lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. See Hargis v. State, reversed on other grounds in State v. Hargis. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, Lawyer Love's, and Lawyer Hilton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members is unforgivable to wit. After the Star Chamber meeting, the three quote-unquote public officials simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours and minutes before. Number 12, Mr. Williams needs to examine Judge Glanville, Lawyer Hilton, Lawyer Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception, the subject of same, and order the court reporter to produce any transcript of same and or unseal all documents from these potential improper ex parte communications. Undersigned counsel needs to cross-examine all of these parties to ensure that the sworn testimony is spread in open court on the record. Number 13, Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton, all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America, has been attacked by the conduct of these three actors. Whoa. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. Number 14, judges must scrupulously avoid improper ex parte communications, whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte anytime the judge is aware of grounds to do so. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that helping Lawyer Love and Lawyer Hilton to influence Mr. Copeland to change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself at the behest and encouragement of Lawyers Love and Hilton to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand. The law must be followed. Judge Glanville must be recused and disqualified from Mr. Williams' case instanter. Number 15, no hearing is actually needed to reach the finding of that recusal of Judge Glanville instanter is mandated. Judge Glanville has automatically caused his recusal and disqualification from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. If this honorable court disagrees, Mr. Williams respectfully requests a hearing, as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. Number 16, this judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County DA's office, and stains the courts throughout the state of Georgia and our country. What occurred in this Star Chamber outside of the view of the cameras, in the shadows and hidden from Mr. Williams and his counsel and the public, is unpardonable and all in violation of Mr. Williams' constitutional rights stated herein, as well as in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret Star Chambers proceedings, which the state of Georgia has promised its citizens it would never engage. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly. Our system abhors star chamber proceedings with good reason. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside of the lens of the cameras. These public officials shall never be trusted by Mr. Williams or undersigned counsel. There are serious consequences for those intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed, disqualified, instanter from Mr. Williams' case. Number 17. As sworn to in Exhibit A, Judge Glanville, Lawyer Love, and Lawyer Hilton conspired to conceal and suppress Brady v. Maryland evidence. This star chamber cannot prohibit Brady evidence from coming forward. That is exactly what Judge Glanville, Lawyer Love, and Lawyer Hilton planned to do. Mr. Williams' constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for the statements of a sworn witness have been obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. Number 18. The June 10, 2024 Star Chamber meeting between Judge Glanville and Lawyers Love and Hilton undermine the public's faith in the integrity of the justice system, as it conceals from the public Mr. Williams, his lawyers, and the others facing the removal of their liberty critical information about the lawfulness and reality of how they are being prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed judge and the state actors. See, for example, Owens et al. V. Hill. Number 19, Judge Glanville at the indecorous Star Chamber ex parte meeting provided legal advice and direction to Attorney Bumpus about how to speak with her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there is actual bias, as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. It is impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed upon the one ex parte communication that has come to light thus far. Judge Glanville, Lawyers Love, and Hilton have infected the process of Mr. Williams' trial and have illegally poisoned same forever. Number 20. Judge Glanville had the ethical duty to recuse himself sua sponte once he had these ex parte communications. However, neither Judge Glanville, Lawyer Love, nor Lawyer Hilton uttered a word that they spent the morning of June 10, 2024, leaning on Mr. Copeland to testify for the prosecution against Mr. Williams, coaching Attorney Bumpus on what and how to sell to Mr. Copeland the proposition to cause him to testify at trial against Mr. Williams, coaching Mr. Copeland on how to deliver his testimony, and last promising Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told a, quote, bold-faced whopper. These public officials, end quote, heard and failed to reveal that Mr. Copeland confessed to committing every indicted offense in this case. Even non-lawyers can see that Judge Glanville, Lawyer Love, and Lawyer Hilton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, Lawyer Love, and Lawyer Hilton have made themselves witnesses whom Mr. Williams' counsel will call. These three lawyers must be recused and removed from this case. Number 21. It is important to note that Judge Glanville originally denied Mr. Williams' request for access to the June 10, 2024 ex parte hearing transcript, keeping context of the record totally hidden by Lawyer Love, Lawyer Hilton, and Judge Glanville. Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Lawyer Love, Lawyer Hilton, and Judge Glanville worked to effect change. Number 22. On Monday, June 17, 2024, Judge Glanville denied undersigned counsel's motion to recuse and went forward with the trial of this case. Similarly, Judge Glanville denied the Honorable Douglas Weinstein Esquire's motion to recuse on June 12, 2024. Judge Glanville then continued to unlawfully preside over Mr. Williams' jury trial. Judge Glanville must be removed as he has proven to have an actual bias as well as the appearance of bias. Footnote 8, Mr. Williams' counsel has announced in open court that he will call these three offenders at trial. Judge Glanville, Lawyer Love, and Lawyer Hilton's names appear on Mr. Williams' filed 8 amended lists of witnesses. Number 23, undersigned counsel has never been afforded the questions that Lawyer Hilton and Lawyer Love created and gave to Mr. Copeland. Undersigned counsel has never been given this list of questions, even though Judge Glanville has been made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. See Exhibit B. Specifically pages 13 and 19. The question must be asked why Judge Glanville has ex parte access to Lawyer Hilton and Lawyer Love's questions for a witness. This conduct is beyond repair. Number 24. Judge Glanville, Lawyer Hilton, and Lawyer Love did not give a hint that they were meeting ex parte with witness Copeland on the morning of Monday, June 10, 2024, or at any time. Undersigned counsel had no idea that Judge Glanville, Lawyer Love, and Lawyer Hilton would dodge the law and ethical rules to conduct this improper and unethical ex parte conference. Judge Glanville and Lawyers Love and Hilton were duty-bound to immediately announce to Mr. Williams, his counsel, and all accused and their counsel that 1, this ex parte meeting occurred, 2, Brady and Giglio evidence was obtained, and 3, that the transcript was made and allowed argument to flow. Instead, their cover-up equals their misdeeds. Number 25, Judge Glanville, Lawyers Love, and Hilton, acting in concert, hid Brady evidence and attempted to normalize this unconstitutional Star Chamber meeting, unethical conduct, and witness intimidation by deflecting the focus on how undersigned counsel learned of the secret proceeding. Judge Glanville held undersigned counsel in contempt of court. This misconduct by Judge Glanville, Lawyer Love, and Lawyer Hilton undermines trust in judges and prosecutors, cannot stand, and cannot be rewarded. Action must occur in order to attempt to remove this dark cloud over Mr. Williams' trial and the criminal justice system at large. The conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville can never be forgotten, normalized, or ratified. Number 26. The Georgia courts have always safeguarded and separated prosecutors and their duties from judge and their duties. Here there is no daylight between Judge Glanville's and Lawyers Hilton and Love's improper and unethical conduct. All must be removed from Mr. Williams' case, instanter. As stated, 27. As stated herein, Mr. Williams intends to call Judge Glanville as a witness at trial, as well as at this recusal motion's evidentiary hearing, based upon his improper conduct and the need to make a further record to protect Mr. Williams' constitutional rights. Specifically, there appear to be communications not captured on the transcript of the June 10th ex parte meeting. Lawyers Love and Hilton and Judge Glanville's examinations are needed to complete the record. Number 28, Judge Glanville is a necessary witness in Mr. Williams' trial, and his name will be used when undersigned counsel cross-examines Mr. Copeland when asking questions. Number 1, whether Judge Glanville pressured Mr. Copeland to testify. Number 2, whether Mr. Copeland realized that Judge Glanville was allowing wrong propositions of law to be explained to him. And number 3, the fact that Glanville condoned Mr. Copeland lying under oath unless it was a, quote, bold-faced whopper. This mandates that Judge Glanville not be in the courtroom in front of Mr. Williams' jury ever again as a judge. Judges must be disqualified in proceedings in which their impartiality may be reasonably questioned, including but not limited to instances where the judge is likely to be a material witness in the proceedings. Number 29, grounds for recusal are contained in OCGA 15-1-8, as well as the Georgia Code of Judicial Conduct. Further, the judge should be disqualified for bias against a party if such bias stems from an extrajudicial source and results in an opinion on the merits on some basis other than what the judge learned from his participation in this case. The alleged bias of the judge must be of such a nature and intensity to prevent Mr. Williams from obtaining a trial uninfluenced by the judge's bias. In the case at bar, it is impossible to honestly find that Judge Glanville is an impartial, fair jurist. Recusal is mandated. Number 30, under Rule 2.11 of the Code of Judicial Conduct, a judge must avoid all impropriety as well as the appearance of impropriety. Judges shall disqualify themselves in proceedings in which their impartiality might reasonably be questioned. The fact that Judge Glanville's impartiality might reasonably be questioned is grounds to mandate that he is removed from this case. Rule 2.11 provides an additional rule of disqualification that is broader than our statute. Here, under any definition and any rule, Judge Glanville must be removed instanter from the position of judge. In fact, commentary 2 to Rule 2.11 explains that judges are subject to disqualification whenever their impartiality might reasonably be questioned. Judges should disclose on the record information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if the judge believes there is no legal bias for disqualification. Number 31, impartiality might reasonably be questioned means a reasonable perception of lack of impartiality by the judge held by a fair-minded and impartial person based upon objective fact or reasonable inference. Recusal on this ground requires a rational basis for such questioning, not an arbitrary basis, even though no actual impropriety on the part of the judge has been shown. As seen in Exhibit A, Judge Glanville's impartiality under this definition has been satisfied. Further, the Code of Judicial Conduct mandates that the judge step down from proceeding over a case where the judge is likely to be a real and essential witness and where there is not substantially the same testimony available from another witness. Judge Glanville must leave Mr. Williams' case, except when he is called to testify as a witness to explain under questioning his misconduct and bias before the jury. The bias of Judge Glanville is of such a nature and intensity to prevent Mr. Williams from obtaining a trial free from Judge Glanville's bias and prejudgment. Prejudice, bias, or prejudgment, or even an exhibition of partisan feeling is present in Mr. Williams' case, and Judge Glanville must be removed instanter. Number 33. Mr. Williams asks this honorable court to hold an evidentiary hearing on this motion to recuse in order for Mr. Williams to gain a full understanding of the misconduct of Lawyer Love, Lawyer Hilton, and Judge Glanville throughout the case. Judge Glanville is so involved in this controversy that his objectivity can reasonably be questioned, and he must be removed as the judge over Mr. Williams' jury trial. Number 34. The facts are so clear that Judge Glanville, in order to shield himself and his co-prosecutors, Love and Hilton, from the truth of their misconduct, denied Mr. Williams' June 17th motion to recuse without a hearing, without providing a transcript, and without permitting another court to hear the motion to recuse dated Monday, June 17, 2024. And this demonstrates that Judge Glanville is involved in this controversy and cannot be deemed fair and impartial. Number 35. The rules of disqualification pursuant to OCGA 15-1-8, as well as the Code of Judicial Conduct, are in play. Number 36. Significantly, Judge Glanville is required to avoid not just impropriety, but the appearance of impropriety in his activities. This is because public confidence and in respect for the judiciary and our courts must be maintained. As shown in Exhibit A, attached here too, the shocking conduct of Lawyer Love, Lawyer Hilton, and Judge Glanville proves that bias and prejudice have been shown, and it would be error for Judge Glanville to continue Mr. Williams' case. Number 37. It has been held to be elementary that a judge must be disqualified when he is going to be a witness in the same proceeding. 38. In the case sub judice, Judge Glanville has taken on the prosecutorial role against Mr. Williams and hence must be recused. These circumstances illustrate perfectly the inescapable conclusion that Judge Glanville is partial to the prosecution and biased against Mr. Williams. Number 39. Judge Glanville attempted to cover up his and lawyer Love's and Hilton's misconduct by attempting to intimidate undersigned counsel and then holding undersigned counsel in contempt of court, sentencing undersigned counsel to the maximum number of days, 20, to serve in custody, for doing nothing but zealously and ethically upholding his professional responsibilities. Judge Glanville then took action before the jury after recusal motions were timely filed by the Honorable Douglas Weinstein as well as undersigned counsel. All of these actions taken by Judge Glanville after these ripe and valid recusal motions were filed are void. Judge Glanville has caused Mr. Williams immeasurable suffering and prejudice based upon his lawyer Love's and lawyer Hilton's denial of Mr. Williams' statutory and constitutional rights stated herein. Mr. Williams must be granted a reasonable bond. Mr. Williams' statutory right to speedy trial has been totally upended by lawyer Love, lawyer Hilton, and Judge Glanville, and Mr. Williams must be cleared of all baseless charges. Number 40. As spelled out above, the supplement to motion to recuse is timely filed, as same is filed not later than 5 days after undersigned counsel affiant first learned of these additional grounds for disqualifications, to wit, on Monday, July 1st, 2024, when the ex parte transcript was first revealed to undersigned counsel. Number 41. The attached joint affidavit memorialized as Exhibit A supports this recusal motion by giving fair support to the charge that Judge Glanville's bent of mind may prevent or impede impartiality as required for Judge Glanville to preside over this case. Judge Glanville's extrajudicial misconduct cannot be ignored. Judge Glanville, lawyer Love, and lawyer Hilton have worked in lockstep to ensure that Mr. Williams' constitutional and statutory rights to a fair trial, impartial tribunal, due process, right to be present at all critical stages of his trial under the federal Constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution, right to cross-examine, right to present a defense, right to effective assistance of counsel, right to assist as counsel, have all been crushed. This trial is a farce. Let's get that right. Denying this motion to recuse and permitting Judge Glanville to continue as judge perpetuates injustice. This case can never return to constitutional normalcy based solely upon the improper misconduct of lawyer Love, lawyer Hilton, and Judge Glanville. Any tragic conviction and sentence in this case will likely be reversed. Judge Glanville has made himself a necessary witness as has lawyer Love and lawyer Hilton. Should Judge Glanville not recuse, Mr. Williams will be prevented from exercising his constitutional right to call witnesses, as Mr. Williams needs to show the jury how and why lawyer Love, lawyer Hilton, and Glanville were not just, quote, doing their jobs, but were teaming up with the united front to convict Mr. Williams. Once armed with this evidence, the jurors can then properly determine what, if any, of this testimony and these facts will bear on their verdicts. Judge Glanville must be removed. Number 42. Mr. Williams' motion to recuse an affidavit timely filed on Monday, June 17, 2024, required Judge Glanville to answer a legal question as to whether the motion to recuse meets the threshold requirements under USCR 25.3. This is simply a question of law. Judge Glanville, acting way outside the parameters of a fair and impartial jurist, denied Mr. Williams' motion, finding that it did not meet the simple threshold requirements of USCR 25.3. Mr. Williams' June 17th motion to recuse in the attached affidavit clearly met the threshold requirements of USCR 25.3. This June 18th ruling clearly shows the bias of Judge Glanville. On Monday, July 1st, Judge Glanville allowed undersigned counsel's June 17th motion to recuse to be forwarded to another court. While this shows that there is at least a reasonable appearance of impropriety by Judge Glanville, judges shall disqualify themselves from any proceeding in which their impartiality might reasonably be questioned. Judges shall perform judicial duties without bias or prejudice and shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice. Judges shall be faithful to the law and maintain professional confidence in it. Judge Glanville has violated all of these critical and worthy principles. Judge Glanville had the duty to act at all times in a manner that promotes public confidence in the impartiality of the judiciary. As seen in Exhibit A, Judge Glanville has abrogated this duty. A hearing must be held to properly document the misconduct between Lawyer Love, Lawyer Hilton, and Judge Glanville. A full evidentiary hearing must be conducted where Lawyer Love, Lawyer Hilton, and Judge Glanville will be called by undersigned counsel as witnesses to determine the nature and scope of their relationship and misconduct. C. Serdula versus State, Supra. A full evidentiary hearing was held on the motion to recuse. Number 43. Before the jury, Judge Glanville will be spoken about in terms of his work as a member of the prosecution team. Judge Glanville will be called as a witness by Mr. Williams. The law mandates that Judge Glanville be removed from presiding over Mr. Williams' case because he cannot be both a witness and judge in our criminal justice system. Judge Glanville has given Lawyer Love, Lawyer Hilton, the Honorable Attorney Bumpus, and Witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Judge Glanville, Lawyer Hilton, and Lawyer Love should have separate and distinct roles in our criminal justice system. These distinctions between these roles has been washed away in Mr. Williams' case. When the judge instructs Mr. Williams' jury that by no comment, ruling, or action taken by the trial court should the jury determine that the judge has any bias in favor of a party. This will be a disputed point of law. Mr. Williams will be calling Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jurors must learn the conduct of these three lawyers when examining the evidence and evaluating this instruction. Love. Wait a minute, I lost my place because I had to cough. This will be a disputed point of law. Mr. Williams will be calling Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses, and thus this instruction does not apply to Mr. Williams' case. Mr. Williams' jurors must learn the conduct of these three lawyers when examining the evidence and evaluating the instruction. Judge Glanville is a necessary witness in Mr. Williams' trial and must be recused. Lawyers Love and Hilton are necessary witnesses in the case and must be disqualified. Number 45. As attested to in Exhibit A, Judge Glanville received extrajudicial information and also gave opinions and legal advice that included but are not limited to that 1. Mr. Copeland went to prison for crimes committed on behalf of YSL, a contested fact in this trial. 2. Mr. Williams and the other co-indictees know Mr. Copeland and his criminal conduct that is not known to Judge Glanville or the prosecutors. Number 3. Mr. Copeland will be cross-examined on his other crime evidence because Mr. Williams and the co-indictees have far greater knowledge of Mr. Copeland and his background than others. And 4, the like. By embracing this extrajudicial information, Judge Glanville believes that Mr. Williams is involved in criminal activity with Mr. Copeland, and Judge Glanville expressed that fact to Mr. Copeland in order to push Mr. Copeland to testify against Mr. Williams. These conclusions regarding facts that are in dispute about Mr. Williams' guilt mandate Judge Glanville be removed from this trial. See Exhibit A. Moreover, Judge Glanville's derogatory and prejudicial statements and demeanor must be considered by this honorable court as attached in Exhibit A. Judge Glanville had an ethical duty to disqualify himself in this matter as he clearly has a personal bias and prejudice concerning Mr. Williams, the other co-indictees, Mr. Williams' counsel, and the other defense lawyers in the case. Judge Glanville has violated his oath by not voluntarily disqualifying himself to avoid this impropriety and appearance of impropriety. Instead, Judge Glanville, Lawyer Love, and Lawyer Hilton have manufactured an unfair, unconstitutional, broken trial and has caused Mr. Williams severe prejudice by incarceration for over 2 years without bond and a laughable trial that has lasted entirely too long, with the games played by Lawyer Love, Lawyer Hilton, and Judge Glanville. Judge Glanville must be removed instanter. Number 46. The instances discussed herein, as well as in Exhibit A, represent more than mere friction between zealous counsel and a diligent jurist. Judge Glanville's conduct created the realistic impression that he has harbored an inclination to be biased against Mr. Williams and partial towards lawyer Love and Hilton and the Fulton County DA's office. Although proven, this honorable court need not decide whether such bias or impartiality actually existed, because Judge Glanville was ethically bound to disqualify himself whenever his impartiality might reasonably be questioned, including instances where Judge Glanville's behavior could indicate that he has a personal bias or prejudice against a party or a party's lawyer. Judge Glanville's impartiality is more than questionable, and it is error to permit him to continue on Mr. Williams' trial. As shown herein in the attached affidavit, Judge Glanville is disqualified from any contact with this case moving forward based upon his bias against Mr. Williams and or his counsel, which stems in part from extrajudicial sources and results in an opinion of the merits on some basis other than what Judge Glanville learned in his lawful participation of the case. Number 47. As cited above, ex parte communications are presumptively harmful error. The state has the burden of rebutting the presumption of harmful error, which it will not be able to do so. Thus, any conviction and sentence will likely be reversed. Moreover, the issues surrounding the improper, secret, and coercive pressure campaign by Judge Glanville, lawyer Love, and lawyer Hilton will become evidence before the jury. In order to attempt to explain this injustice to the trier of fact, Judge Glanville, lawyer Love, and lawyer Hilton will become witnesses. Mr. Williams is entitled to know these communications between Judge Glanville, lawyer Love, and Hilton, and or Mr. Copeland. Number 48. Judge Glanville, lawyer Hilton, and lawyer Love have stolen forever Mr. Williams' opportunity to have this trial heard by a jury in a constitutional and statutory firm manner. Judge Glanville, lawyer Hilton, and Love have goaded Mr. Williams into moving for mistrial. All of the conduct in all proceedings after the Honorable Doug Weinstein Esquires, as well as undersigned counsel, filed their motions to recuse, and affidavits are deemed invalid and have no effect. Mr. Williams' constitutional and statutory right to a speedy trial has been stomped on by Judge Glanville, as well as Mr. Williams' right to due process and a fair tribunal, and the other constitutional rights stated herein and in the attached affidavit. This conduct must end, and all three of these lawyers must be disqualified from this case. He called Glanville a lawyer, all three of these lawyers. Number 49, the attached affidavit clearly sets forth the facts and reasons for the belief that prejudice and bias exists. These allegations are definite and specific as to time, place, and details as to this extrajudicial conduct or statements which demonstrate both bias in favor of lawyer Love and lawyer Hilton and their positions on behalf of the District Attorney's Office of Fulton County, and prejudice toward Mr. Williams and his counsel. Moreover, there has been a systematic pattern of prejudicial conduct toward Mr. Williams and his counsel and the other co-indictees and their counsel by Judge Glanville, lawyer Love, and Hilton acting together unethically, which has influenced the trial process and has broken the foundation of a fair trial. These are not bare conclusions or opinions, as Judge Glanville attempted to claim after Mr. Williams timely filed his motion to recuse on June 17th. Instead, Judge Glanville was using his position of power and trust to obstruct justice as he violated his oath of office, while lawyer Hilton and Love sat mute as they violated their oath of office and their ethical responsibilities to ensure a constitutionally fair trial. Lawyer Love, Hilton, and Judge Glanville must be disqualified from further action. Mr. Williams must be released from custody instanter and cleared of all charges based upon prosecutorial and judicial misconduct. Number 50. As explained above, ex parte communications are presumed to be error, and once Mr. Williams has shown that Judge Glanville received ex parte communications, there is a presumption of harm that can only be overcome by affirmatively showing that Judge Glanville did not consider these communications. In this case, Judge Glanville has harmed to its core Mr. Williams' constitutional and statutory rights asserted herein. Judge Glanville, lawyer Love, and Hilton are now self-made witnesses and must be removed from this case instanter. Their conduct is reprehensible. Judge Glanville has never affirmatively stated that he has not considered these ex parte communications. Lawyers Hilton and Love have never uttered a syllable denouncing those ex parte communications. Instead, they promote the propriety of these ex parte communications. The state cannot refute this presumption of harm, as Mr. Williams' constitutional right to cross-examination, fundamental right to be present to see and hear all goings-on in the court pursuant to the United States Constitution, as well as Article 1, Section 1, Paragraph 12 of the Georgia Constitution. His right to due process, right to a fair tribunal, right to a fair trial, right to effective assistance of counsel, right to present a defense, and right to call witnesses have all been smashed by the unlawful and unethical conduct of these three supposed, quote, public officials. Judge Glanville, Lawyer Hilton, and Love have a lot of explaining to do and must all be removed from this case except as a witness. Number 51. Judge Glanville had the duty to disqualify himself and recuse himself based upon his misconduct and had a duty to inform all the misconduct of Love and Hilton. See Fitzpatrick v. State. Instead, Judge Glanville, Lawyer Hilton, and Love all proceeded like their conduct was normal, proper, and somehow privileged. Judge Glanville must be recused. Number 52. The law also requires this honorable court to recuse. The public must believe in the absolute integrity and impartiality of judges. That is why, even without a showing of actual bias, prejudice, or unfairness, and regardless of the merits and timeliness of any motion to recuse, it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court, which sits in the same circuit. The Supreme Court of Georgia observed that our Judicial Qualifications Commission has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. The Honorable Court of Appeals of Georgia has explained that, as cited above. The Commission concludes that it would be inappropriate for this Honorable Court to preside in this action where Judge Glanville holds a judicial office in this Honorable Court same circuit. Therefore, under law, this Honorable Court must recuse from this case because refusing to do so would permit questioning of this Honorable Court, something that court will not countenance. This court must recuse as well. An appearance of impropriety exists in situations in which reasonable minds might perceive that this Honorable Court's ability to carry out its responsibilities with impartiality and integrity or competence is impaired. Furthermore, this Honorable Court has received a $2,000 donation to its re-election campaign from Judge Glanville in April 2024 during the pendency of Mr. Williams' trial. Judge Glanville giving this contribution for re-election could be deemed as exceptionally large campaign contribution, and thus is another reason this court must recuse from presiding over the case. Judge Glanville's donation to this Honorable Court's re-election campaign 3 months ago, coupled with the above-cited case law and Judicial Qualifications Commission Opinion 220, mandate that this Honorable Court must recuse from this case as it meets in private with Judge Glanville and the other Fulton County judges to conduct the business of the Fulton County bench. There is an appearance of impropriety by ruling on this motion to recuse. Wherefore, based upon the above and attached joint affidavit, as well as timely filing of June 17, 2024, motion to recuse and attached joint affidavit, Judge Glanville must be recused. The Honorable Court must also be recused. Respectfully submitted on this 8th day of July. Signed, Brian Steele and Keith Adams.
Okay, thank you. We're going to go down all the way down to the email now.
There's a Randa. Is Randa going to read?
Randa?
I'm here.
We're going to go down to the email.
You did good, girl. You ain't even need my help.
Now, thank Liz for the help of reading, y'all. Hold on. We're going to go all the way down. Hold on, y'all. I'm going to go all the way. It's 233 pages, y'all. We're going to go down to... There we go. We're almost there. $231.
What is it? The email?
Yeah, the email. 231. Page 231.
Okay. I'm not sure. So is this to, okay, this is to Courtney Edwards?
Copeland. This is page.
I know, but it says Max. It says Max Sharp, and then it says to Courtney Edwards up there.
Yes.
Okay, so this is from Melnick to Love, the Steele Law Firm, Sharp and Hilton. Let's see, they CC'd somebody else on there. Antonio Long. Okay. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him, I wait, okay. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case. And I spoke with Miss Love early in the process around the time jury selection was beginning. I have a plea. I have a plea with Judge, who is that? What is that? Carnicel? Tomorrow at 9, and I will come to the courtroom as soon as I am done. So then they say, John. See, he says John, which is Melnick. So then Hilton responds, "Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that we were not his attorney. Wait, that you were not his attorney, and he had not spoken with you. However, if you are certain that you are his attorney, we will cease communication. But your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we were planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. Yours in service, Hilton." So Melnick responds, "Good afternoon, all. It has come to my attention that the Fulton County District Attorney's Office has questioned my client. Okay, did I read that already?
No, it's a new one.
Okay. Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, Melnick." But look at the date. It says June 6th. This is the day before Copeland took the stand on the 7th. Like 4:31. This is what they talked about in court.
So, but then they end up giving him that the judge signed off on immunity the next morning. You guys saw that. Hold on, let me go back up and show you guys that the day the judge signed the immunity.
So basically, after Melnick advised them that Copeland would be getting on the stand pleading the fifth, that morning, June 7th, they went and got that order signed by the judge so that they could force his testimony.
Notice that they didn't include.
There it is right here. Y'all want to read it, Rand, on this one right here?
We already read the immunity
I know
one.
there's people who haven't seen it, ma'am.
How many pages is that?
That's only 2 pages.
Okay, I guess.
Go ahead. This is it.
All right, y'all. It's the immunity. Okay. State of Georgia having moved this court pursuant to I swear I read this the other day. OCGA to compel the testimony of witness Kenneth Copeland and District Attorney Fannie T. Willis. Is that how you say it, Fannie? Anyway, having determined that the testimony of Kenneth Copeland is necessary to the public interest. Kenneth Copeland, having been properly subpoenaed to appear before this court to testify in the state of Georgia, having provided to this court sufficient reason is in support of his motion to compel the testimony of Kenneth Copeland. The court finds that Kenneth Copeland has been properly subpoenaed to appear before this court to testify to the trial of the instant case, and that the testimony of said Kenneth Copeland is necessary to the public interest. Accordingly, it is hereby ordered that witness Kenneth Copeland shall appear before this court beginning Friday, June 7, 2024 at 9 a.m. and provide testimony to the trial of the above style case, and shall continue to appear and testify until released by this honorable court. Further, pursuant to OCGA 24-5-507, said Kenneth Copeland shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from testimony of Kenneth Copeland given by Kenneth Copeland as required under this oath, shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Kenneth Copeland shall be subject to prosecution or to penalty or forfeit for any perjury, false swearing, or contempt committed to testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court, other state, United States, or any other state. Finally, it is ordered that should said Kenneth Copeland refuse to testify after this order is entered, said Kenneth Copeland shall be subject to being adjudged in contempt to this court and shall be subject to commitment by this court to the Fulton County Jail until such time as said witness purges himself of contempt by testifying as ordered to do so by this court and this order. This order shall be entered of record in the minutes of this court, and any testimony given my bad, y'all, by Kenneth Copeland pursuant to this order shall be transcribed and filed for permanent record in the office of the Fulton County Clerk of Superior Court. So ordered this 7th day of June 2024. Signed by the judge.
So the email came out 4 o'clock on the 6th, and this order was done the next morning at 9 a.m. on the 7th. What do you think, guys? Thank you for reading, but I'm gonna put the link in here for folks to come on in and give an opinion. Randa, what do you think?
No, I was just gonna say that was a good motion still put in. He came in knocking them down, boy. He did not care. He like, y'all guys to go. We need somebody else on this.
I just think they're doing these men so dirty. It's disgusting, really.
So do you think there's any hope? I mean, there's so much exposure that's going on here now. It's like, is this real?
And notice what he said. He said that he feels there's things missing out of the transcript. Like, you have to highlight that part. Like, he said he feels there's things missing out. So therefore, those 3 need to be questioned and examined, because if he feels there's something missing out of the transcript, I mean, it doesn't look good at all.
And it's like we all knew that there was stuff missing too. So I think it's weird. Miss Sylvia, when you were on Kayla's live a couple nights ago, didn't she say that it wasn't redacted, or that was the gist? Like, she made it sound like, and I'm not like,
no, she basically saying there are things that I guess there was conversation which were not captured because they were not on record, because the court reporter had, was out at one point. The judge
that was client privilege.
Yeah, and then they had conversation on the side, which the judge and the court reporter did not hear, so they were not put on it. So that's why Woody would say there was this. It should have been. It's redacted because he knows he was in conversation, but he didn't know when it was not on record and when it was on record. He may not know the difference.
Oh, okay.
So I don't think it was explained to him, hey, at this time, you're going to talk to your lawyer. It's not going to be on record right now, that type of stuff. But you did see Miss Weaver have at one point saying that judge walked out or off record and things like that are coming back on record. So.
And that was the whole email chain, y'all. It was only 2 pages.
No, there was another email. The FU one is not on there yet. It's not. You don't
right. No, I'm saying in this. They were asking, was that all the email chain in this?
Yeah, that's it for that one. But there isn't.
Yeah, that's it as his exhibits.
Yeah. If anybody want to come up and give us your thoughts on this, and we're going to be on for a few minutes, not long.
Yeah, I'm going to drop down because I got to get back to work.
Thank you. Thank you. Thank you, Rand.
Bye, y'all.
Bye. Did anybody want to come up? Okay. All right, great. Thank you, Liz, for reading, and I appreciate you guys. That's it. Well,
No worries.
if
You're welcome,
anything,
y'all. Have a good day.
yeah, if anything comes up and anything pops up, we will come back and we will have a reading on it. Also shout out to Doug Daly, because he the one who put it out there first, and I picked it up and I decided to put it on here for you guys, that you guys hear it instead of having to read it, because people like me don't like to read. But anyway, you guys have an awesome, wonderful day. God bless y'all. Bye.